And that new issue, my Lord, has been identified as the fact that the National Assembly passed its resolution or considered and passed its motion, and that is what has then given a rise to this cause of action. My Lord, it is not disputed that the National Assembly passed its motion on the 8th of October this year. And again, my Lord, you will clearly see from the ruling of your brother, Mr. Justice Mugambi, that the parties before you today were before him on the 9th. On the 9th of October this year. And my Lord, the fact that Mr. Justice Mugambi's ruling of the 11th of October takes on board the fact that the challenge by the petitioner is both to the proceedings in the Senate and National Assembly, I submit that it was then the petitioner's duty in petition 522 when we were before your brother Mr. Justice Mugambi on the 9th to point out in petition 522 that there were new facts that necessitated his consideration of prayer number 6 in the notice of motion dated the 2nd of October that was before him. That prayer is the same prayer as prayer number 5 that has been urged before you today. That was the right thing to do. My Lord, that having not taken place, and the petitioner having elected to file this petition and the notice of motion that is before you this afternoon, that deed by the petitioner amounts to forum shopping. And I urge your Lordship, therefore, not to proceed and hear and make a determination on the notice of motion that is before you in petition 550 of 2024. My Lord, a possible way out or a remedy has been suggested by my good and learned friend, Mr. Macharia, that the remedy is to stay these proceedings. Or the remedy is to stay 522. My Lord, that request or that motion is not before you. And I submit that, my Lord, the correct thing to do, petition 522 being the first in time, and so as therefore, my Lord, not to be an accessory in forum shopping, what your Lordship should do is direct that this petition be consolidated with petition 522 of 2024, and any relief sought in notice of motion dated the 11th of November, 11th of October, 2024, be canvassed in the consolidated petition 522 of 2024. Any prayers, any relief that is sought, notice of motion dated the 11th of October, 2024, be canvassed within the context of that consolidated petition. To go on and entertain and make a determination as you have been invited to by the petitioners, would my Lord would then be facilitative of forum shopping. My Lord, my learned colleagues who will submit after me will submit extensively that the process which the Senate has now embarked on is guided by certain constitutional timelines. And in deference to those constitutional timelines, my Lord, the remedy that the judiciary has come up with is to acknowledge that the High Court's ability to examine, if it has that ability, is postponed until the constitutional process, governed by strict constitutional timelines, set out in Article 145, Subarticle 3, 4, 5, 6, and 7 of the Constitution, is completed by the Senate. My Lord, I am of the view that you should not consider any of the substantive arguments that have been made in support of the notice of motion in respect of public participation or otherwise. But, my Lord, if you are in the unlikely event minded to consider those arguments, I wish to submit that the total population of Kenya is not a factor to be considered when determining whether public participation was effective or not. Article 118 of the Constitution places an obligation on Parliament to facilitate public participation. But the public have no compulsion to participate. There is no corresponding duty in the Constitution that when public participation takes place, then all citizens or a certain category of citizens of Kenyans must participate. And, my Lord, if that argument were to be given any credence, then it would be possible to challenge the election of an elected official by reference to the turnout of voters. You are elected in constituency X where there are 20,000 registered voters. Only 2,000 came out and voted in the election in which you were returned. That is the way the Constitution works. There is no compulsion that everybody takes place. There is no threshold set out in the Constitution for a return on public participation. Again, my Lord, the reference to an opinion poll and to pollsters is again irrelevant in assessing the adequacy or the efficacy of public participation. I submit, my Lord, that in promulgating the Constitution in 2010, the people of Kenya were very deliberate as to the structures and institutions they set up. There are thresholds contained in Article 145, and those thresholds refer to numbers of members of Parliament, both of the National Assembly and of the Senate. And if there are any numbers to be referred to, it is those set out in Article 145. My Lord, there is an allegation that there was a resolution passed at night. And there was a concern at the speed at which the process is taking place. Again, in that submission, there is no statement that the second respondent proceeded or sat irregularly, or that the transition of the resolution from the National Assembly to the Speaker was irregular. My Lord, all of them took place within the prescribed constitutional parameters. And the speed at which any of those took place is not impeachable unless it can be established that they took place outside the time prescribed by the Constitution. My Lord, in respect of the order from your brother, Mr. Justice Mwongo, in Kerugoya, and I'm glad to note that my learned colleague, Mr. Ndego Njiru, is now present. When we were before Mr. Justice Mwongo, an attempt to make these submissions that have been made on the part of the petitioner, that there was non-compliance with that order, were made. Mr. Justice Mwongo, and you will see from the pleading, direct that nevertheless, that Kerugoya matter be consolidated with matter before the three-judge bench. And my substantive submission is as follows. There is reference to a petition in Kerugoya where Mr. Justice Mwongo gave certain parameters in which public participation must take place. I believe it is petition number 14.
It's in his supplementary affidavit.
It is in the supplementary affidavit filed as annexure RG 19. My Lord, my submission is that this cannot then be the forum in which that order is enforced. There is a direction that a bench will be established. I am not sure whether Her Ladyship, the Chief Justice, has established a bench. This matter is not consolidated with the matter where the Kerugoya matter has been consolidated. And it cannot then be a proper exercise of this court's jurisdiction to turn petition number 550 of 2024 into the enforcement proceedings or orders made in petition number 14 of 2024 in Kerugoya. I yield the rest of our available time to Mr. Gumbo and Mr. Wanyama to conclude our missions. I'm most obliged. My Lord, perhaps if you could be kind enough to add us some time. I was making submissions on an important issue, and I believe we all agree that it is important. My Lord, we are entirely in your hands. What we seek for is a little more time so that we can put the other issues. No, I would not ask your Lordship for the entire day. On top of what we have, my Lord, would you consider 10 minutes? Then maybe 10 minutes so that we conclude? We use the 4 that we have plus 6 more? What would sit well with your Lordship?
Because each one will leave us for time extension. So how much time is it?
I leave it entirely to you, my Lord.
Conclude. I'll give you another 3 minutes. That makes 7.
My Lord, have you factored in the time that we stopped? I must oblige, my Lord.
My Lord, allow me to, in a very brief way, just add to what my learned senior, Mr. Nyamodi, has already presented on behalf of the second respondent. My Lord, I start from the decision that has been referred to in, or rather the matter that is filed before Kerugoya, your brother, Justice Mwongo. I just want to add one small thing to that matter. My Lord, a lot of submission has been made in relation to whether there's been compliance with that direction or the directions of your brother in Justice Mwongo in Kerugoya in petition number 14 of 2024. My Lord, it is my submission
that a question as to the compliance or otherwise with the directions of your brother, Justice Mwongo, can only be made, my Lord, in that very file. That file is before you. My Lord, you'd be handicapped to make a finding as to whether there's been compliance or otherwise with the directions of your brother. Very quickly then, my Lord, to a submission in relation to Article 145, my Lord. This entire process is hinged on Article 145 of the Constitution. Article 145(1) relates to the process in the National Assembly. My Lord, submission has been made before you from both sides of the bar that process has been concluded. In fact, that there's been a resolution that has been sent to the Senate pursuant to the provisions of Article 145, 1 and 2 of the Constitution. My Lord, why that is important is that it signifies that Article 145(3) has kicked in, which means that the Senate is now properly seized of the matter. In fact, learned senior counsel, Mr. Muite, did indicate that there is already a hearing schedule, and we confirm, my Lord, that that is accurate, that this matter is meant for determination and deliberation on Wednesday and Thursday of this week. My Lord, if that be the case, where then is the efficacy of issuance of any conservatory order? We ask ourselves, my Lord, that given the jurisprudence that has emanated from this court, the Court of Appeal, and the Supreme Court, the position, my Lord, has been that deference and judicial restraint should then be exercised so that the process that starts from the National Assembly into the Senate is completed. It is only then that the High Court would come in, if at all, to inquire as to whether anything done under the provisions of the Constitution is indeed done in compliance with the Constitution. My Lord, I in particular make reference to decisions that have been placed before you. There is a decision by the Supreme Court in Supreme Court Petition number 11 of 2022. Mike Mbuvi Sonko. My Lord, it appears as, I think, number 7 in our list and bundle of authorities.
What are those bundles? You keep on talking about bundles. They're in the system.
Yes, my Lord.
And I'm here.
My Lord, I think that's why we were trying to draw the difficulty that we found ourselves in, because we received them this morning. We received submissions this morning. We received bundles this morning. It is only today that we could respond. My Lord, can I suggest that we can print and avail them before you? My Lord, can we give an undertaking to print those documents, avail them before you shortly after proceedings? Thank you, my Lord. My Lord, in the Mike Mbuvi Sonko matter, we particularly refer you or invite your attention to the to paragraph 136. My Lord, to paraphrase, the Supreme Court expressed itself to a worrying trend where there is litigation that is conducted before another constitutional process is carried out. And in their wisdom, they gave guidance that in such instances, my Lord, the courts they gave guidance that in such instances, my lord, the courts would exercise judicial restraint, they make an inquiry. Similarly, Lord, in, again, the decision by the Supreme Court in a case of Justice Kariuki Mate and others, that's petition number 32 of 2014. It appears as number 8 in our list of banned authorities. I invite your attention to paragraph 61, 62, and 63. Petition number 32 of 2014. '61, 62, and 63. Particular, if may, Lord, just paragraphs alone. Court says that from the course of reasoning and from cases, it is possible to formulate certain principles as follows: that A, each arm of government has an obligation to recognize independence of the other. B, each arm of government is due to refrain from another organ or how to exercise its mandate. C, that the courts of law are the proper judge compliance with constitutional edict, all public agencies. But this is attended with the duty of objectivity and specificity in the excess of judgment. They end by saying, my lord, that when such matters are then presented before the court, then the court is asked or directed to exercise restraint, to only intervene after the entirety of that process has been completed. My lord, the last thing that I would want to speak to is the question of whether there will be any prejudice that will be occasioned in the event that the orders sought are not granted. It's a question of whether there will be any prejudice that will be occasioned in the event that the orders sought are not granted. My lord, our constitution, specifically Article 145 sabbatical, has an inbuilt safety valve, inbuilt mechanism that, number one, provides for an opportunity for, in this case, the petitioner. Article 145, it's couched in terms that the president, in this case the deputy president, shall have the right to appear and be represented before the special committee during its investigations. So I'm just saying, my lord, that that safety valve gives an opportunity for, number one, the petitioner to is made. But what's more, that after this process would have been concluded, then in case it becomes necessary, nothing stops the petitioner, Kenyan, from making an inquiry from the courts as to whether the entire process was in compliance with the Constitution. So at no point, and the courts are always able to fashion appropriate remedies at whatever point in time when such issues are raised. My lord, lastly, it should not be lost on us that the Kenyans, in framing this specific Article 145 of the Constitution, just like most of the other provisions, were very mindful of the need to determine and conclude these matters with urgency. That is why timelines are therefore defined for the commission of these processes. In the case of this impeachment, petition at Article 145, Article 3, sets a timeline of 7 days. Granting order may then mean extending the scope of that constitutional edict. 145, 3. It then means, my lord, that if interventions were to be gotten this point in time, then as of necessity, it will put the other actors, the other state organs, who are indebted to also independently carry out their obligations, in a difficulty in terms of finding those orders. My lord, that is not a situation that a petition is supposed to precipitate if the Constitution was to be read holistically. I stop at that unless there's any other question. Yes, madam.
And the same constitution says At the end of the exercise,
Yes.
another person should be there within the period.
So first, it gives a period of 14 days within which then the president can nominate a person to be considered by the National Assembly for the position of deputy president.
That means within 14 days there should be someone.
Yes, but then if that is not the end, because that person again is subject to approval by assembly for within another 60 days.
Now we are not on there, we are still at the stage where there should be someone.
Yes.
What happens then? What happens then? When we be asked the same question that now the Constitution provides the same timeline, you cannot intervene.
Not quite. You know, the independent processes that as I look at them, my lord, once that entire process has been completed and a determination made, the provisions that then govern the question of replacement are completely different. At that point in time, in my humble view, the court can consider a question as to whether what has been done can then be what is in compliance with the Constitution. Thank you, my lord.
Yeah, thank you, my lord. I will not take a lot of time. Just address the issue of conservatory orders.
You're giving me your 30 minutes. It will not take a lot of time.
Yes, my lord.
You're giving me your 30 minutes.
Thank you, my lord.
I've added it, upgraded it from 25 to 30.
That's all, my lord. I'll take that time. My lord, I will begin first of all by submitting on the practical implications of the orders of the proceedings before your brother, Justice Mugambi, in petition 522 of 2024, vis-a-vis these proceedings. My lord, and I want to make the firm submission that, my lord, the petitioner in this matter, who is the petitioner in 522 of 2024, is precluded by the doctrine of estoppel of record. From raising petitioner in 522 of 2024 is precluded by the doctrine of estoppel of record. From raising issues, and my learned colleague Mr. Paul Nyamundi has raised these issues, raised this point, issues that he has raised in petition 522 in this instant petition. My lord, let me just be very clear that in 522 of 2024, my learned colleague Mr. Ongoya, as led by Senior Counsel Paul Mwite and assisted by Faith Waigu and Mr. Macharia, who are in these proceedings, firmly told the court and submitted in this very bench that they were not pursuing the prayer for conservatory orders. At that very moment when they were making those submissions, the proceedings in the National Assembly with respect to impeachment, phase 1, had been concluded. So, my lord, they only pursued one question. That is the question of certification. My lord, actually, if you look at the proceedings, they raised an objection. My lord, they raised an objection, my lord, to our submissions opposing conservatory orders, stating that it was not one of the matters which they wanted canvassed. So, my Lord, the implication of these submissions.
Do I understand you to say that they didn't want you to respond to the application for conservative order?
Yes, my Lord. In petition 522 of 2024, because according to them, they didn't want to argue that petition, that aspect of the prayers. All they wanted was for certification. So, my Lord, if you now look at the ruling of Justice Mugambi, he only addressed the issue of certification. So that, my Lord, in terms of the implication, our submission is that if there is any value to be derived from this application, the value is for them to ask that this application be consolidated with petition 522 of 2024. My Lord, that will be consistent with the Mutunga rules, especially Rule 2, which requires, and my Lord, public policy in the judicial decision making. My Lord, public policy in the judicial decision making. My Lord, which requires consistency, that litigants need to lay a platform for consistency in judicial decision making, so that there is no conflict from decisions which are rendered by our honorable judges. So, my Lord, that public policy will be given effect by the order for consolidation, which, my Lord, you have jurisdiction, inherent jurisdiction to make, even when they have not asked for that order today. You have inherent jurisdiction to make. My Lord, I'll briefly mention the test on the ground of conservatory orders. My Lord, they have submitted, the petitioner submitted that he wants conservatory orders to stop proceedings in the Senate. My Lord, my submission is that if you examine the nature of proceedings for impeachment, my Lord, Article 145, these proceedings have not completed. My Lord, proceedings in the National Assembly and proceedings in the Senate are one continuum. My Lord, both the National Assembly and the Senate are arms of Parliament. So, my Lord, there is no decision yet by this arm of government with respect to impeachment to, of necessity, require this court to issue conservatory orders at this stage of these proceedings. So, my Lord, if you look at the test for the grant of conservatory orders, which my colleague, Senior Counsel Paul Mwite cited, in the case of Peter Gaterau Munya, my Lord, my colleague didn't cite the last part of the test. My Lord, which requires you to consider, my Lord, and make a delicate decision. Apply the doctrine of restraint and make a delicate juridical decision to allow these proceedings to go on. Why, my Lord? Because of a foremost constitutional value known as the constitutional doctrine known as the doctrine of separation of powers. My Lord, these proceedings which are before the Senate are legitimate constitutional proceedings. My Lord, public participation has been conducted. They can question the adequacy of that public participation But, my Lord, public participation has been conducted to a sufficient degree of acceptability. My Lord, that is why in the response, my Lord, you can see numbers being quoted by the petitioner. So, my Lord, if I submit that if there was no public participation in these proceedings, in the impeachment proceedings, my Lord, then that will have made a lot of sense to injunct the proceedings at any time when the petitioner comes to court. Because, my Lord, public participation is a core constitutional value. So, my Lord, because public participation has been conducted, the delicate exercise of judicial function, my Lord, then requires that you hold on a little bit. You don't issue precipitate conservatory orders to stop this legitimate constitutional process of impeachment. My Lord, the implication on the opposite side is that, my Lord, these proceedings are not about criminality, impeachment proceedings. My Lord, they are about political responsibility. And, my Lord, in the design of the 2010 Constitution, my Lord, they exist in the constitutional and legal order for good reasons, my Lord. My Lord, they exist so that the legislative arm of government is able to hold certain state officers, my Lord, into account. So, my Lord, they are not illusory or unknown proceedings to law. They are proceedings which are recognized by Article 150, Article 145, and Article 146 of the Constitution. My Lord, secondly, these proceedings are time-bound. My Lord, in the case of Justice Kariuki Mate, and, my Lord, the case of Justice Kariuki Mate, my Lord, is a typical case, my Lord, for you to apply in this matter, because, my Lord, the facts appear to be tailored for this kind of situation. My Lord, petition 32 of 2014, Justice Kariuki Mate versus Martin Nyaga Wambora. A similar matter, my Lord, where you, my Lord, petition number 32 of 2014. My Lord, and I would like to briefly, my Lord, reflect on what the Supreme Court has said in paragraph 83 of this decision. Paragraph 83 of the decision. 83, my Lord. So, my Lord, the Supreme Court is asking itself a question. That, my Lord, shall ex parte orders be issued? And in this case, my Lord, we are reformulating by interpreting, because the implication is the same. Shall conservatory orders be issued, my Lord, with respect to proceedings which are active before the legislative arm of government? And, my Lord, you can see here the Supreme Court is restating the doctrine of separation of powers as one of the principles which shall guide you in that paragraph 83. Because, my Lord, the implication of the conservatory orders is that then the proceedings, these time-bound proceedings, my Lord, these time-bound proceedings before the legislative arm of government will then be stopped. And, my Lord, I submit that it is not unique for the Constitution to require this kind of proceedings to be time-bound. And, my Lord, in paragraph 84, to require that you exercise what the Supreme Court judges are called inner restraint. Inner restraint. Because, and my Lord, the Supreme Court is saying exercise this inner restraint in the context of express mandate allocated under the Constitution to Parliament. And my Lord, the idea is to circumvent and avoid conflict and crisis. Conflict and crisis in the discharge of constitutional responsibility. So, my Lord, we are urging that you give deference, that, my Lord, you allow, at this point in time, these proceedings to go on before the legislative body and to exercise judicial restraint and not to issue conservatory orders. My Lord, exercising judicial restraint, as I submitted, is in line with the test for the grant of conservatory orders in Peter Gatirao Munya. My Lord, again, on the second limb on that question, my Lord, they have imputed, the petitioners have said that standing orders number 64, my Lord, does not provide for adequate time to do public participation. My Lord, they made that submission. And my Lord, I would like you to look at the same decision of Kariuki Mate, paragraph 93. Because, my Lord, standing order number 64 is made pursuant to the provisions of the Constitution. My Lord, standing order number 64 is made pursuant to the provisions of the Constitution. And here, my Lord, the Supreme Court is saying that these standing orders are necessary for the orderly conduct of the business, the operations within the legislative arm of government. So, my Lord, I want to submit that these standing orders then enjoy the presumption of constitutionality. So, my Lord, the standing orders provide that if a motion is introduced before the House, the National Assembly, for the impeachment of President and Deputy President, my Lord, the standing orders require that that motion be dispensed of, my Lord, within 7 days. My Lord, within 7 days. And, my Lord, that takes us again back to the doctrine of time-bound proceedings. My Lord, within 7 days. My Lord, what that means...
So, which law says 7 days?
My Lord, standing orders, my Lord. So that, my Lord, now going to the Constitution. My Lord, Article 145 on the removal of president, which Article 150 equates, that shall also apply for the removal of deputy president. My Lord, Article 145, paragraph 3 also says within 7 days of receiving the resolution from the Speaker of the National Assembly. My Lord, within 7 days from receiving this resolution from the National Assembly, my Lord, the Speaker of the Senate is supposed to commence action, proceedings towards the completion of the removal of, or otherwise, of the Deputy President. My Lord, to consider the motion, my Lord, to commence the proceedings to consider that motion for the removal of President stroke Deputy President. My Lord, thereafter, they only have 10 other days, my Lord, 10 other days to finish the process, to make a decision. My Lord, you can correlate this to Article 140 of the Constitution of Kenya, which requires that a petition once presented to the Supreme Court for the validity of a presidential election must be determined within 14 days. So, my Lord, it's not unique for these proceedings to be determined in this manner. My Lord, there are constitutional policy reasons why that is the case. My Lord, perhaps because this position is important and stability of the nation is very critical, you don't want to keep people in abeyance. on who is their president and deputy president. My Lord, the deputy president, when there's a vacancy in the office of president, they're supposed to assume office as president. So, my Lord, because of these constitutional timelines, then one of the reasons one, my Lord, can make is that because of the stability of the nation, you cannot have a vacancy in the office of president and deputy president within this kind of periods. That is why the Constitution, my Lord, has set strict timelines for determination of questions concerning their removal from office or election into office. So that, my Lord, this is now tied on the public participation. So that, my Lord, what happens on the public participation, my Lord, is that whereas public participation is not provided for in Article 64 of the Standing Orders, my Lord, public participation is a constitutional imperative which so many authorities have laid down, and including this court, my Lord. So, my Lord, this constitutional imperative known as public participation must be done within the confines of the timelines which have been laid down. So, my Lord, the National Assembly was required to do public participation, my Lord, within those timelines and not create excuses. And my Lord, that's what the National Assembly did. Public participation within the constitutional timelines. My Lord, submissions was made by Senior Counsel Paul Mwite on whether a response by the Deputy President is needed when you are going to public participation. My Lord, in my view, that is stretching the issue too far. My Lord, what is before the House of the National Assembly is often a motion. And my Lord, the Constitution talks about a motion for the removal of Deputy President. My Lord, that motion, before it is determined, public participation must be conducted. So, my Lord, the obligation of Parliament is to ensure that that motion goes to the people, for them to air their views on what they think the motion, on what they think the elected members should do with the motion. And my Lord, it is important to mention that sovereignty, they exercise it directly or indirectly through their elected representatives. So, my Lord, there is no obligation whatsoever to send a response to the people, because by that time, there are no proceedings contemplated in the standing orders for pre-impeachment public participation, because there is no motion. It will be speculative to go to the people with a motion which has not been introduced to the House for adjudication. Just like this court cannot adjudicate, my Lord, on a petition which is not before it. People will be talking to the media about the petition, but the High Court will only be seized of that petition when it is brought before it. My Lord, that is very important to distinguish. And my Lord, the efficacy of or adequacy of this public participation my Lord, because it was done, cannot be considered at this stage of the proceedings. My Lord, the petitioner is inviting you to make conclusive determination on the question of public participation. My Lord, the response from the National Assembly that public participation was indeed done, and the mere fact that it was done, then, my Lord, you cannot consider that on merits at this stage. So, my Lord, we urge that you don't grant the Conservatory orders. So, my Lord, the application of the Conservatory orders will to destabilize the process which is before the Senate My Lord, there is no timeline, there is no guideline on what happens when the court has issued conservatory orders. What happens to the timelines in Article 145? What happens to those timelines when conservatory orders are issued? My Lord, the doctrine of proportionality in the Mutunga rules require that you exercise some restraint as not to issue conservatory orders at this stage. My Lord, Senior Counsel Paul Muite talked about gross violation of the Constitution as one of the grounds. He says the motion does not meet the motion for impeachment. But my Lord, again, in the Sonko case, the Supreme Court has said the role of the court is not to look at the merits of these allegations. My Lord, instead, the High Court is supposed to just look at the process issues. Has the National Assembly complied with the standing orders and the provisions of Article 145? My Lord, if the answer is yes, then, my Lord, you allow those proceedings to continue and conclude. My Lord, now that my colleague, Senior Counsel, talked about gross violation of the Constitution, my Lord, allow me to say that indeed, from the motion, the Deputy President, there are serious allegations that the Deputy President is facing. And my Lord, as I wind up, my Lord, the Deputy President is participating in the proceedings before the Senate. My Lord, that is important. He is participating in the proceedings before the Senate as we speak. So, my Lord, he cannot approbate and reprobate. He cannot participate in the proceedings before the Senate. My Lord, yes, my Lord, the process is going on. My Lord, allow me to quote a document, my Lord, which, because I'm not speaking from the bar. Yes, my Lord. Yes, my Lord. From a response which was filed, which we have filed, and which also my colleague have filed, my Lord, an affidavit, supplementary affidavit by regarding Gachagua. My Lord, this is what they have annexed. My Lord, they have annexed a letter from the Senate inviting them to submit a response by 5 p.m. today, stating that the motion is before the House. They were given material which constitute this motion, and they were required to file a response. My Lord, under Article 145 of the Constitution, those proceedings have already commenced. My Lord, what I'm saying is that the 10 days for the Senate to consider that question have already commenced. The proceedings are active before the Senate.
Idea as to whether it's actively engaged. What you refer to a document that he has been invited.
Yes.
Not a document that he has filed.
That's correct, my Lord.
So can we restrain ourselves to that point?
Okay, my Lord. I will rephrase then, my Lord, by saying that the Senate has invited the Deputy President,
That's fine.
yes, to appear, my Lord, before it to answer on these weighty allegations which the petitioner says concern gross violation of the Constitution. My Lord, now that brings out a fundamental point. My Lord, he has opportunity in accordance with the provisions of Article 50 of the Constitution. My Lord, he has opportunity to air his grievance in a trial process at the Senate. My Lord, that's a fundamental tenet of the doctrine of natural justice. He has been given an opportunity to come and ventilate his concerns about public participation, about the content of their motion, the allegations he is facing. He has opportunity to ventilate those concerns in a quasi-judicial process, my Lord. My Lord, quasi-judicial process. So, my Lord, it's better that we allow him to exercise his opportunity to appear before this quasi-judicial process for the trial of these allegations. My Lord, the issuance of conservatory orders will deny the parties that opportunity to subject the allegations against him in a constitutionally tested and compliant process of impeachment. My Lord, the senators act as jurors, as in this case, stroke judges. My Lord, they are required to make up to decide on each and every allegation that he is facing. So, my Lord, the doctrine of ripeness then applies against the Deputy President at this stage of the proceedings. My Lord, his complaint is not ripe for judicial adjudication yet. My Lord, as I wind up, the roof is not on fire. My Lord, the courts of the doors of this court have not closed at him to come and ventilate his concerns about the entire process completed. But after the impeachment proceedings have concluded. And my Lord, this is the tenor and the effect of their submission in petition 522 of 2024. Whereas conservatory orders were sought, they abandoned the quest for conservatory orders in 522 of 2024. My Lord, the questions concerning public participation have been certified as raising substantial questions of law in 520 of 2012. My Lord, there's a prayer on arresting, suspending, or interfering with the decision of the Senate in 522-2024. And my Lord, those proceedings anytime now will be before. Then in these proceedings, they will be doing what we call lemon selling. If they seek conservatory orders, these proceedings, they'll be doing what we call lemon selling. My Lord, I request a case and pray that you don't consider granting the orders for conservatory orders at this stage. Indeed, my Lord, if there's any decision with respect to consolidation, my Lord, we concede that this petition can be consolidated with petition 522, my Lord, for good order, my Lord, so that there is no conflict in terms of decisions which are made by the High Court on the same subject matter, my Lord. My Lord, with respect to the same on the same subject matter, my Lord. My Lord, with respect to the same petitioner. My Lord, the same petitioner. Thank you, my Lord.
Yes, my Lord. Yes, I have my time.
I need to ask a question to
Yes, my Lord.
you refer to paragraph 93.
Yes, of the
Although I understand what is
yes. And therefore,
I just wanted to understand.
yes.
What I see here.
Yes, that's correct, my Lord.
Thank you, my Lord.
You say you want your 30 minutes.
I'll try and be brief since my colleagues have covered.
They said that you have
preliminary objection, my Lord, I wish to refer you to civil application from the Court of Appeal in Nyeri, number E093 of 2023, Kawera Mwangaza versus the County Assembly of Meru. Civil application number E093 of 2023, Court of Appeal at Nyeri. Parties are Kawera Mwangaza versus County Assembly of Meru and the Speaker of Meru and the Speaker of Meru. My Lord, in this matter, it's in our list of authorities at paragraph 22. The Court of Appeal found that they do not have jurisdiction. Oh, sorry, my Lord, at paragraph 21. They do, yes, my Lord. They do not have jurisdiction in the first instance to consider the merits of the application for conservatory orders before the impeachment process has run its constitutional and legal course. They downed their tools at that point because the matter was pending before the legislature. They then proceeded to say that Honorable Mwangaza still has an opportunity to appear before the Senate, and if she is impeached, she still has the right to approach the court for appropriate relief.
Until?
Sorry, my Lord?
Until?
Oh, I'm saying, and after that, the court proceeds to say that if the petitioner, in this case, Honorable Mwangaza, is impeached, she still has the right to appear before the Senate. Okay, let me go back. This court lacks jurisdiction in the first instance to consider the merits of the applicant's application, which sought conservatory orders before the impeachment process has run its constitutional and legal course. They then proceed to say, even then, if the impeachment process runs its course, she still has a right to appear before the Senate, and she still has a right to approach the court for appropriate relief, yes. So at this point, the petitioner finds himself in the same circumstances as Honorable Mwangaza. He has produced the invitation from the Senate. He has produced the invitation from the Senate to provide his documents this evening by 5. He has produced an invitation to appear on the 16th and the 17th of October. My Lord, the Senate is the impeachment court. That is the trial court. The petitioner has a right to appear there, present his evidence, rebut what the National Assembly has presented to the Senate, and it is only once that is concluded that he can seek to invoke the jurisdiction of this court. My Lord, I also wish to rely on the Supreme Court decision of Karaoke Mate, which has been extensively cited this afternoon. Because if you exercise your jurisdiction and grant the orders that the petitioner is seeking, the effect will be to stop a constitutional process. And at paragraph 84 of the Karaoke Mate decision, the court said that no government, 84, the Supreme Court says no governmental agency should encumber another to stall the constitutional motions of the other. My Lord, the 10 days for the Senate are already running. If you issue a stay of those proceedings, it brings the constitutional process to a halt, or puts the Senate and the Speaker in a position where they have to decide whether to comply with Article 145 or to comply with decisions of the courts. And that was why Kariuki Mate had initially been convicted of contempt, because he was forced to choose between the two. My Lord, we ask that you allow the Senate to conclude and then give whatever appropriate reliefs. And at this point, my Lord, that is why the petitioners have been unable to demonstrate that their petition will be rendered nugatory if these orders are not granted. It will not. What they will do is to take the outcome of the decision in the Senate, which may even be in favor of the petitioner. He may or may not be removed. We do not know. And then approach this court for appropriate reliefs. At this point, nothing will be rendered nugatory if the Senate is allowed to proceed with its constitutional mandate. And my Lord, I wish to tie this to Gatirau Peter Munya's principle of public interest. The Supreme Court said